Otherwise, I can be very short.
Yes.
We're delighted to hear. Really referring simply now to the Court of Appeal's judgment, which is in Appendix Part 1, 1 of 2 at tab 2, and in particular their reasoning really from paragraphs 103 through to the end of the judgment. We say, with respect, that there are a number of difficulties flowing from those paragraphs. First of all, we respectfully submit that they have in effect used a categories approach to the question whether a Middleton inquest is required. So they have reasoned that that the soldiers generally are to be analogised with conscripts, and as a result there will always be a need, based on category as it were, for a Middleton type inquest, and we say that doesn't fit well or at all with the reasoning of the House of Lords in L amongst others, which splits trigger and content in the manner I indicated. All treats content as the principal question. Secondly, we respectfully submit that it flows from the reasoning of the Court of Appeal that there will, on their reasoning, always be a need for a Middleton inquest whenever a soldier dies on military operations abroad. And we respectfully submit, it maybe it's a subspecies of point 1, we respectfully submit that's a surprising position to reach, because there may be circumstances in which there's nothing in the rationale that govern or underpin Article 2 which would require that. And thirdly, we have, with respect to particular concern on the concealed issue, if that's the right way of putting it, namely the substantive obligation that is owed, and the Court of Appeal's reasoning, which appears to have been that because there are certain cases decided in Strasbourg which involve conscripts in which an Osman type obligation has been owed, therefore it follows that that sort of obligation will be owed in all circumstances and in relation to all soldiers. And we respectfully disagree with that for the reasons that I went through before the short adjournment. We're particularly concerned about the whether or not properly to be drawn, there is properly to be drawn an analogy between conscripts and those conscript cases and ordinary soldiers in any event. And that is because, as we read them at least, those conscript cases are not authority for that breadth of proposition, at least insofar as they relate to suicides of conscript. They arise out of the heightened risk of suicide that conscripts as a particular group give rise to. And moreover, the risk which is being protected against there is the risk of suicide. It isn't, on any view, a risk against all the potential eventualities of armed conflict or of military operations. And we submit, therefore, with respect, that there is no true analogy between whether in terms of a jump over into the content of inquest or a jump over into the terms and form of the substantive obligation. There isn't a true analogy to be drawn between those conscript cases and soldiers more generally. And so we submit in conclusion that the issue which appears truly to have divided on issue 2 is whether or not there must always be a Middleton type inquest, and whether or not one can answer that question now and in the abstract, as it were. The respondents take the position that this must be a Middleton inquest. We take the softer position that that depends, that isn't required. It depends upon all the factors that I identified earlier on, and is a fact and context-specific matter which will need to be considered by the coroner in the new inquest. As part of that, if it is necessary to examiners, we assert that it is, at least for the purpose of determining whether there's an arguable breach of it, the content of the substantive obligation. We say, for all the reasons I went through before the short adjournment, and indeed for all the reasons that are set out in our case, that the substantive obligation, the Osmond-type obligation, does not arise in the context of soldiers on military operations abroad.
Can I just be quite clear about that, Mr. Reedy? You're suggesting that it would be for the coroner to decide whether the facts as presented to him give rise to the need for a Middleton inquest.
Yes.
Would his decision on that point be judicially reviewable?
Yes.
Mm-hmm. Yeah.
He would need to decide on in accordance with the facts and circumstances that were before him. And as I indicated before the short adjournment, that isn't a set question in terms of time. It's a question which he will keep under review as the inquest progresses.
Yes.
And for all the reasons I went through, he can travel down, as it were, Jameson paths, and it's only if he runs up against a dead end of a place to which he feels it's necessary to go in order to ensure that the inquiry that he undertakes is effective, that he will need to consider the matter further, and that arises both in relation to scope and in relation to the content of the verdict or the inquisition at the end. And also, those are my submissions in it.
Thank you very much, Mr. Saney. Yes, Ms. Ruth.
My lords, my lady, Mr. Eady's submissions on the first issue, the question of jurisdiction under Article 1, depend, in my submission, upon his basic proposition that the concept of jurisdiction as defined at Article 1 of the Convention is, as he put it, unique to the Convention and different from the concept of jurisdiction in international law generally. From that basic proposition, looking in particular at Bankovich, he identified 3 limits that he said were particular to the concept of jurisdiction in the Convention. The first was that jurisdiction is primarily territorial. The second was that he said it requires, although it would seem not in every case, the effective exercise of control within the espace juridique, by which he means the area covered by the Council of Europe states. In other words, it's regional in its effect. And the third is that the rights bestowed by the Convention are indivisible and cannot be divided or tailored, so that any situation in which individuals fall within the jurisdiction of a state, he argues, carries with it the implication that that state falls under a duty to secure to the individual all the Convention rights. He also appeared to be submitting at times that in order to succeed, we had to bring ourselves within the scope of one of the already defined specific exceptions to the territorial nature of jurisdiction as he had identified it. Although when pressed on that point, as I understood it, he accepted that that was not so and said ultimately that the court ought to apply a precautionary approach and develop pre-existing exceptions to the territorial principle only on a step-by-step incremental basis. That, as we understand it, is how he puts his case on Article 1. Our submission is that the basic proposition that Article 1 means something different when it talks about jurisdiction from the concept of jurisdiction in international law is incorrect. And that the limitations that Mr. Eadie has sought to identify are in fact merely features that flow from the European Court's human rights attempts to apply the normal principle of jurisdiction under international law. And in particular, they stem from that court's attempts to deal with the question of jurisdiction in one specific factual situation. And that is the situation in which it is said that the basis for jurisdiction outside the state's own territory is that the state is in effective de facto control of a particular area. Now, I'm going to come on to consider in particular the cases of Bankovic and Al Sadoun, which consider the scope of the principle of effective control of an area. But our submission, in summary, is this. What was special about Bankovic was the argument that the applicants were running in that case. The applicants, of course, were those who had been victims of an airstrike. And their argument was that the mere fact that member states of the Council of Europe were in a position to launch an airstrike on them outside the territory of those states in itself indicated that those states were in a position to exercise sufficient control to bring the victims within their jurisdiction. And it was in the context of that argument that where the state is able to violate your rights, it must follow that they have jurisdiction for the purpose of the Convention. It was in rebutting that argument that the European Court of Human Rights was engaged in the case of Bankovic. And in my submission, the comments in that case about espace juridique and about the question of all rights having to be guaranteed and not divided and tailored is specifically in relation to that question. When does a state's de facto control over an area outside its territory become so significant and complete that it can be said that that state exercises jurisdiction extraterritorially? But the court in Bankovic was not being asked to consider what in our submission is the orthodox case, the standard case, the a fortiori case of extraterritorial jurisdiction, which is not the case of effective control over an area. It is simply the case in which international law, either as a matter of customary international law or because of particular treaties, recognizes the right of one state in law to exercise public and governmental powers on the territory of another state.
To exercise governmental and what?
And public powers, what you might characterize as state powers on the territory of another state. Because in general, for a state to do that would infringe the sovereignty of the state whose territory is engaged. But there are specific circumstances in international law where such an exercise is permissible. And examples are activities carried out by consuls, for example, entry visas, passports, protection for nationals.
Those activities being carried on in the office?
In the territory of another state.
Well, yes, just get it absolutely clear.
Yes.
They're sitting in their office in another
Yes.
state
Yes.
with the Union Jack flying from the flagpole,
That's
or whatever
right.
it is, and that's where they are, and that's what they're doing
That's
in
right.
that place.
Yes, they're carrying out public governmental type powers, issuing visas, giving or withdrawing passports, seeking to, in one case, discover the whereabouts of a child who had been taken by her father to Jordan. Those are the kinds of examples of the sorts of activities that one might think of as public governmental powers. Another example is the example considered in Drozd, although it didn't arise on the facts in Drozd, but would be where there was a treaty between two states which permitted judges of one state to sit on the territory of the other in their capacity as judges of the first state, because that would be an exercise of a public state sovereign power of one state on the territory of another. So that's George. And another example,
Can I? And then
Yes.
in the consular type
Yes.
case, one's contemplating an infringement of the convention by, for example, discrimination, the Roman rights type situation.
that's one
it?
example. There is a case which is a UK case that I'm going to show the court in a minute, where the complaint was by a British woman who had been married to a Jordanian man. They had a child. He took the child to Jordan, and she complained that the British consul in Jordan had not done sufficient to protect the Article 8 rights of the child and of herself by seeking the return of the child to the United Kingdom. On the facts, they found that the consul had done enough, but they held that there was jurisdiction to consider the complaint. Now, so those are, in my submission, cases that are not in any way an extension of the concept of jurisdiction. They are classic, well-recognised forms of exercise of extraterritorial jurisdiction. And they are completely different from the effective control over territory example, which was under consideration in Bankovic and Al-Sadoun. And in my submission, it is self-evident when one considers those examples that issues of espace juridique or indivisibility of rights are not in play in relation to that type of jurisdiction at all.
Well, I understand the first point, because we're outside the area of the member states.
Maybe in any country.
Yes, well, I'm assuming we're in a third country outside the Council of Europe.
It's no different if it's Jordan or if it's France.
Quite so, but why discard, or indeed are you discarding, the principle that these rights are owed under Article 1 to everyone, and you owe all those rights to everyone? That's the...
Because in my submission, what is recognised in those cases, and the Jordan case is a good example, is that actually the powers of the particular government official in the foreign state are likely to be very limited. And to give the Jordan example, the British consul wouldn't be able to guarantee the right to marry to a British citizen in Jordan. Have no influence over that at all. But that doesn't mean that there isn't an exercise of jurisdiction by British consuls in relation to passports, visas and other matters where they do have jurisdiction.
So,
Yes.
yeah, you're saying that, I suppose you would say that the duty is owed to everyone, but the consul can't discriminate between one person and another, but there's a limit on the rights that can be afforded because of the nature of the office and the place where it's being exercised. Is that how it comes? And so you're saying that one can, as it were, pick and choose between rights in that situation?
Indeed, often you'll have a treaty which only permits the state to exercise a particular power on the territory of the state. An obvious example is the Drojd example. Let's say you had a treaty between two states that enabled the judges of one state to sit in the courts of another state. Now, obviously, those judges would be in a position to guarantee Article 6 rights and would be under a duty to ensure that their trials comply with Article 6. But again, they would have no influence over Article 12 rights.
In other words, the rights which arise within the context or the sphere of the power that is being exercised,
Yes.
only those which are germane to those.
Yes, my Lord.
There.
Yes, my Lord. And we submit that there is a clear distinction between what we say are, in fact, the easy cases, which are cases of the exercise of a sovereign power overseas, and the difficult case, which is the Bankovic Al-Sadoun case, where you're talking about de facto control of a territory. Our next submission, as the court will have anticipated, is that we submit that the circumstances of a member of the armed forces serving with the British Army overseas fall simply within this classic category of extraterritorial jurisdiction. And I'm going to deal in some detail with a topic which my learned friend, with respect, has not touched upon, which is the question, as a matter of international law, of the jurisdiction that a country has over its armed forces when they are overseas.
And you're going to be able to show, are you, that this is a recognised exception? I'm taking that word from Bankovich, paragraph 93.
Yes.
It is recognised.
Yes, my lord. Recognised as a matter of customary international law, and also recognised in specific treaty provisions and international provisions, and indeed in national law as well.
I mean, Mr. Rose, I mean, consuls, of course, owe this duty, it's long established, to those with whom they deal, in respect of whom they are exercising this UK governmental and public power.
Yes.
But that says nothing about whether they themselves are owed any rights under the Convention.
Well, there are 2 points in answer to that. The first key point is that Private Smith, or any soldier in the British Army, is wearing 2 hats. He is simultaneously himself the agent of the state, exercising sovereign power, but also subject to the lawful authority and jurisdiction in the classic sense, himself, of the British state. Because what I'm going to show to your lordships is that it is the United Kingdom which has exclusive jurisdiction over Private Smith and other British soldiers in Iraq in terms of criminal and civil law, in terms of every aspect of their discipline and welfare, and indeed that Iraq had no jurisdiction at all over him, either in terms of his own legal conduct or in terms of owing him any duty of care or questions of welfare and discipline. And the reason is that actions of the United Kingdom government in relation to its own troops overseas are regarded as actions of the state and outside the scope of the powers of the receiving state. They remain within the jurisdiction, in the classic sense, of the United Kingdom. His legal position in Baghdad is the same as his legal position in London. We also submit that Mr. Eadie's precautionary approach with respect takes the matter somewhat too far. The Ullah principle, famously, is no more but certainly no less, just as much as it is no less but certainly no more. The duty of this court, we would respectfully submit, is to reach the right answer and not to err on the side of the state. Now, it's been suggested that it would be easier for the respondent, i.e. us, to get to Strasbourg than for the government to get to Strasbourg, and that might be a reason to err in favour of the state. But your lordships and your ladyship will have already seen the question mark in this case, about the extent to which Private Smith himself would actually be a victim of any decision that there was no jurisdiction for soldiers outside military bases, given that he himself died on a military base, and there doesn't appear to be any challenge to the question of jurisdiction. Now, I say appears because there is some lack of clarity with respect to Mr. Eadie on this point. In their skeleton argument in the Court of Appeal, the Ministry of Defence stated that insofar as the factors that led to Private Smith's death, which might have included his stint at the fuel distribution centre in full sun, for example, occurred outside the base, they would be outside the scope of Article 2 and any Article 2 investigation. Now, the extent to which that is being pursued, or if it is, whether it could or might make a difference in his case, is far from clear, especially having heard Mr. Eadie's very substantial concessions today in relation to the Article 2 investigative obligation. But what it does mean is that it might be just as difficult for the claimant in this case to get to Strasbourg as for the government. And we submit that the right approach is both parts of Ullah, no less but no more, and equally no more but no less. But more fundamentally, we submit that the precautionary approach is irrelevant to our case because, for the reasons I've already given, we submit that this is an a fortiori case. It is a much more straightforward case for the establishment of jurisdiction than the effective control of territory cases in Bankovic or Al Sadoun. With respect, what the government have done is to take two cases that deal with a somewhat unorthodox extension of the notion of jurisdiction and to argue that that is now the only basis for extraterritorial jurisdiction under the Convention, ignoring the more orthodox and well-established bases of extraterritorial
Well, I'm
jurisdiction.
not quite sure that Mr. E went that far. I think he did recognise consuls and people on vessels and that kind of thing. I mean, his point, as I understood it, because I tried to put this to him, was that there wasn't any recognised exception in the favour of armed forces, and that's what I would be very interested to know about.
Well, my Lord, as a matter of fact, there are a number of cases in which it has been stated by the Strasbourg Court that armed forces remain under the jurisdiction of their sending state, and I shall come to those in due course.
I mean, I think noted that at pages 19 and 31 of your printed case, you say on each occasion that the European Court of Human Rights in Strasbourg has repeatedly held that the armed forces remain within the jurisdiction within the meaning of Article 1. You say it in subparagraph I at page 19, and then you say it again at page 31, paragraph 84.
Yes, ma'am.
And I'm afraid I've just got question marks all over those paragraphs, but you're going to show us these cases where okay.
And is it true that our forces in Germany, for example, are not subject to local laws? I mean, we have armed forces stationed in various places in Germany, and no doubt they're subject to military discipline as well, but I think in practice, if some offence is created when they're out of uniform and around the town, the German authorities will be allowed to prosecute.
Well, my Lord, where you're talking about NATO deployments, there is an international agreement called the Status of Forces Agreement, which makes detailed provision as between NATO states for the extent to which each state retains jurisdiction over their armed forces. And generally, where you're talking about the consensual deployment of forces from one state to another, there will be some form of agreement, either if it's not express, it will be implied, about the terms on which those forces come there. And again, there is authority on that, and I'm going to show it to your lordships.
But as Oppenheim, the old edition of Oppenheim says, as regards the safety of his army and the purpose of war, the occupant is vested with an almost absolute power.
Yes, yes, my Lord. That's so. If you're talking about a belligerent occupation, yes. And I'm going to show the court an authority about belligerent occupation.
So we're talking in these passages that Lord Brown refers to about belligerent occupation.
Yes. Well, this is the distinction between a situation, let's say, for example, we have US air bases in the United Kingdom, and they're here at with our consent, at our invitation, and there are particular terms on which they're here.
Isn't there a Visiting Forces Act for that?
There is a visiting, indeed there is. But, my lords, we're getting ahead of ourselves because we need to look at these different situations in relation to which there are different international legal instruments, and in relation to which there is actually quite a lot of case law. So can I now come to what we say is the proper starting point? And that is, what is the meaning of the term jurisdiction under Article 1 of the Convention? Because we submit that it is absolutely fundamental to Mr. Eadie's case that he makes the submission that jurisdiction under Article 1 has a unique meaning in the Convention which is different from its meaning in international law. And we submit that is inconsistent with the authorities. If we now go to Bankovic, which is volume 5, tab 47. First of all, the court can see paragraph 36. The submission about jurisdiction that was being made by the respondent governments in this case, including the United Kingdom. As to the precise meaning of jurisdiction, they suggest that it should be interpreted in accordance with the ordinary and well-established meaning of that term in public international law. My Lord Hope asked what was meant by public international law. It's simply in contradistinction to private international law, in other words, conflicts of laws. The exercise of jurisdiction therefore involves the assertion or exercise of legal authority, actual or purported, over persons owing some form of allegiance to that state or who have been brought within that state's control. They also suggest the term jurisdiction generally entails some form of structured relationship, normally existing over a period of time. So your Lordships can see that it was the positive submission of the United Kingdom that the normal international law meaning of jurisdiction should be used, and that they identified two categories of cases. The first of persons owing allegiance to the state, and the second of those brought within that state's control. Then the court's assessment starts at paragraph 54. And we do draw the court's attention to paragraph 54, which we submit as important in understanding Bankovic. The court notes that the real connection between the applicants and the respondent states is the impugned act, which, wherever decided, was performed or had effects outside the territory of those states. It considers that the essential question to be examined, therefore, and I stress therefore, is whether the applicants and their deceased relatives were, as a result of that extraterritorial act, capable of falling within the jurisdiction of respondent states. So it's made very clear that this is a decision made specifically in the context of a situation where there's no pre-existing relationship between the victims and the states, and that it is the alleged wrongful act itself which is said to be the basis of them coming under the jurisdiction of the state. Then, paragraph 55, the court recalls that the Convention must be interpreted in the light of the rules set out in the Vienna Convention. It will therefore seek to ascertain the ordinary meaning to be given to the phrase within their jurisdiction, in its context, and in the light of the object and purpose of the Convention. The court will also consider any subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. Moreover, Article 31(3)(c), this is of the Vienna Convention, indicates that account is to be taken of any relevant rules of international law applicable in the relations between the parties. More generally, the court recalls that the principles underlying the Convention cannot be interpreted and applied in a vacuum. The court must also take into account any relevant rules of international law when examining questions concerning its jurisdiction, and consequently determine state responsibility in conformity with the governing principles of international law, although it must remain mindful of the Convention's special character as a human rights treaty. The Convention should be interpreted as far as possible in harmony with other principles of international law of which it forms part. And they then go on to refer to the travaux préparatoires. And of course, Mr. Eady's stress in his submissions was all on the question of the travaux préparatoires. But that is with respect to subordinate principle for the interpretation of treaties under the Vienna Convention. The starting point is that you must interpret the treaty in accordance with its normal meaning, and that you must interpret it in accordance with the general principles of international law. And just for the court's note, the Vienna Convention itself is in volume 15 of the Authorities Bundle, tab 139. And there your lordships can see the principles of interpretation of treaties set out. Going on in Bankovic, paragraph 59, as to the ordinary meaning of the relevant term in Article 1, the court is satisfied that from the standpoint of public international law, the jurisdictional competence of a state is primarily territorial. While international law does not exclude a state's exercise of jurisdiction extraterritorially, the suggested bases of such jurisdiction, including nationality, flag, diplomatic and consular relations, effect, protection, passive personality and universality, are as a general rule defined and limited by the sovereign territorial rights of the other relevant states, and they then set out a host of citation. Accordingly, for example, a state's competence to exercise jurisdiction over its own nationals abroad is subordinate to that state's and other states' territorial competence. In addition, a state may not actually exercise jurisdiction on the territory of another without the latter's consent, invitation, or acquiescence, unless the former is an occupying state, in which case it can be found to exercise jurisdiction in that territory, at least in certain respects. The Court is of the view, therefore, that Article 1 of the Convention must be considered to reflect this ordinary and essentially territorial notion of jurisdiction, other bases of jurisdiction being exceptional and requiring special justification in the particular circumstances of each case. So we submit that it simply isn't right to suggest that there was any intention in Bankovic to apply a special or unique or different notion of jurisdiction. All that the court was doing was applying what it understood to be the essential principles of jurisdiction as a matter of international law, and noting the point that jurisdiction is essentially primarily territorial, although there are exceptional circumstances in which it can be exercised extraterritorially. And then at paragraph...
Do you know what is meant? Presumably one would find it if one looked at Dr. Mann's writings, but in bracket in paragraph 59, effect, protection, passive personality and universality. I mean, universality would, be arresting in pirates in somebody else's territory?
Yes, I believe that would be in international crimes of yes. Universal jurisdiction.
Effect, protection of your own nationals?
Effects is the effects doctrine of American law, where, as I understand it, where you can take jurisdiction over acts abroad if they have an effect on your territory. Passive personality is where you take jurisdiction on the basis of your national being injured abroad.
And your lordships can see how those concepts tally with the notion of consular and diplomatic officials exercising jurisdiction abroad. Then we go to paragraph 65. We can see the significance of the travaux preparatoires, which in my submission are very limited. However, says the Court, the scope of Article 1 at issue in the present case is determinative of the very scope of the contracting party's positive obligations. As such, the scope and reach of the entire convention system. And then they say, in any event, the extracts from the travaux preparatoires constitute a clear indication of the intended meaning, which cannot be ignored. The Court would emphasise that it is not interpreting Article 1 solely in accordance with the travaux preparatoires or finding those travaux decisive. Rather, this preparatory material constitutes clear confirmatory evidence of the ordinary meaning of Article 1 of the Convention as already identified by the Court. So they don't suggest that the travaux preparatoires support any modification of the meaning of jurisdiction from that which it would ordinarily bear as a matter of international law. The same point has been more recently reiterated by the Court in the case of Andreeva and Latvia. That's at tab 45 of this same bundle. And it's paragraph 56. Tab 45, paragraph 56. The Court reiterates that the concept of jurisdiction for the purposes of Article 1 reflects the term's meaning in public international law and is closely linked to that of the international responsibility of the state concerned. And they cite the Moldova case. Then they say, such responsibility may arise for the acts of all state organs, whether they belong to the legislature, executive, or judiciary. So, if we go back to Bankovic, the starting point is that the court seeks to apply the general principle of jurisdiction from public international law and considers that that principle is primarily territorial, although there may be exceptional cases where jurisdiction may be exercised extraterritorially. And the court in Bankovic then goes on to consider exceptional cases. And the court can see the heading just above paragraph 67, where they start to do that. Extraterritorial acts recognised as constituting an exercise of jurisdiction. And there is particular stress in paragraph 70 in particular on the question of the responsibility of a contracting party when, as a consequence of military action, lawful or unlawful, it exercised effective control of an area outside its national territory, and the corresponding obligation to secure human rights to the inhabitants of that territory. Now, we submit that the stress on that particular form of extraterritorial jurisdiction is explicable, given the way that the case was being put in this case, where it wasn't being said that any of the respondent states had exercised any public or governmental power in relation to these victims, but simply that by launching an airstrike on them, they had, by that act, attained sufficient control over the victims to fall within the scope of this exception. And essentially, it's that argument that the court is going on to examine.
I mean, the whole heading of little c, extraterritorial acts,
Yes.
recognised constituting an exercise of jurisdiction.
Absolutely.
I mean, it's addressing a completely different topic.
Yes, my lord.
It's addressing what it is that your people abroad must do in order to introduce, so to speak, third-party victims.
But
To introduce people.
yes, but specifically in the context of an argument that was based on de facto control of an area, rather than the exercise of governmental power. And that's the analysis that the court can see in detail at paragraph 70.
I mean, can I just see where we're going? I mean, you know, the Court of Appeal, and I rather thought part of your argument, tried to, so to speak, bring this case within certain of the identified exceptions that in Alskany we set out to the primarily territorial scope of the convention. But actually, I mean, your argument isn't really that at all. It's saying those exceptions are merely illustrations.
No.
And this is a completely different, and you say, a fortiori, and much simpler, exception to territoriality.
Well, my lord, I'm going to put it slightly differently from that. What we're going to say is that the starting point is jurisdiction means jurisdiction in international law, that this is a classic instance where it has been recognised for many, many years that states retain jurisdiction over their armed forces abroad, and that we do submit that it comes within the ambit of the exception identified with reference to consuls. And I'm going to show the court the scope of that, because in my submission, consuls are just an example, but the question is an example of what? And the question was put, I believe it was by Lord Mance, where's the underlying principle? Where is the underlying principle for these exceptions? And I'm about to address that question.
Could we just look back
Yes.
at 70? I know
Yes.
this isn't this case, of course, but it's the second sentence which tells us what the obligation is,
Yes.
really as a consequence of the military action outside the lawful territory, but within the espace, of course, as we know in this case.
Yes.
And the obligation is to secure in such an area the convention rights and freedoms.
Yes.
So we're taking the
Yes.
entire package,
Yes.
and that's something that flows in that particular case
Yes.
from the presence of the forces.
Yes,
in
so
that
that exactly, my lord, and so that notion that it's got to be the whole, that you're responsible for the whole package, is specifically in the context of an exercise of jurisdiction which is the effective control of an area.
And it's linked, of course, to the fact that absent the invasion, these rights and freedoms would have been guaranteed
That's
by
your own,
Cyprus itself.
by your own government. That's
Yes.
right. That's right. That is essentially the invading force has ousted the local government, taken on its public governmental powers and now comes under corresponding duties to guarantee the fundamental rights of the occupants. That's the argument. But we submit it has nothing whatever to do with this case.
I mean, that's a specific case confined to Council of Europe territory, which, as you said, has nothing to do with this case.
No, that's right.
No, but it may be helpful,
Yes.
Ms. Rose, just to show what they're thinking about.
I am going.
You
Yes,
know, I mean, it is an extension.
Yes.
It's actually a very logical,
Yes.
Utterly
It is logical.
sound extension, which fills a gap which otherwise would be there.
Yes.
I understand
Yes.
that.
But of course, my learned friend doesn't submit that this notion of the regionality of the convention is essential. One of the oddities of his argument is that he identifies what he calls the restricting principles, but he doesn't even contend that they're necessary conditions. I say that because he accepts that an army base in Iraq is an area under effective control sufficient for this principle to be in play. And of course, Iraq is not within the regional space of the Council of Europe. So with great respect to him, there is something of a confusion internally in his argument.
Ms. Rose, if one just thought of exercising sort of powers and so on, why was it that all the colonies didn't automatically become subject to the Human Rights Convention? Whereas, as I understand it, Article 56, if you
Yes.
ratified, then you
Yes.
could make a
Yes.
declaration.
Yes.
It's just, how does it work? Now, I'm just asking, how does it work that? How does that work on your analysis? Because there must be a classic example of exercise of jurisdiction. I'm sorry, of sovereignty.
Well, my lord, that raises some complex questions about the legal arrangements in relation to former dependent territories, which I'm certainly not in a position to answer at the moment. But my lord, in my submission, it doesn't bear on the central point here.
It was just you put it in such absolute terms.
Yes.
I'm just slightly puzzled
Yes.
by why it is, therefore, that all these colonies didn't automatically just come aboard.
But maybe the answer to that, I'm not saying it is the answer, but maybe the answer is that Article 56, I think it
Well,
was,
that may
wasn't
be
it,
that-
gave an opt-out, in a sense, by saying you can opt in.
Yes, we have to look at.
In other words, provided for
Yeah,
that.
yes. But
Well, can I come back to that
yeah,
question?
I mean, obviously there is a
There is an answer to
There's
it,
a
and-
special term there, which
Yes.
I can see that, but I just don't quite understand how, on your theory, that really should have happened.
Yes, it's dealt with in Quark and the recent
Yeah.
case about Sark.
If we can perhaps come back to that question.
I can't remember what it said.
But paragraph 71 is a summary of the analysis that we've just seen in more detail at paragraph 70. And it's the point that we were looking at, that there may be extraterritorial jurisdiction where the contracting state is in effective control and exercises all or some of the public powers normally to be exercised by that government. Then we come to paragraph 73, where clearly the court is addressing a different category of extraterritorial jurisdiction. And we submit this is the relevant passage for our purposes. Additionally, the court notes that other recognised instances of the extraterritorial exercise of jurisdiction by a state include cases involving the activities of its diplomatic or consular agents abroad and on board craft and vessels registered in or flying the flag of that state. In these specific situations, customary international law and treaty provisions have recognised the extraterritorial exercise of jurisdiction by the relevant state. And the answer to Lord Mance's question, what is the underlying principle governing the exceptions, which otherwise look like a miscellaneous ragbag, and we then have references to Drost and so on. The underlying principle is that these are situations in which customary international law or treaty provisions have recognised the extraterritorial exercise of jurisdiction by the relevant state. In other words, it's a lawful exercise of governmental authority outside the territory of the state. And
by the diplomats,
yes, my lord.
in respect of whether they're
Nationals
UK citizens or foreign citizens.
Yes, it's more likely to be British nationals, but it could equally be somebody
Right.
seeking a visa.
But, I mean, it doesn't say that the diplomats themselves are within the jurisdiction of the UK for Article 1 purposes.
No, my lord, that doesn't. But your lordship has my two answers to that. First, we submit that the person who brings someone under jurisdiction is themselves under jurisdiction. But secondly, and more fundamentally in this case, we submit that Private Smith and the other British soldiers is in the position of the person who is subject to the jurisdiction. He's in the position of the person appearing in front of the judge or the person seeking the visa, because he, serving in the armed forces, is subject to the lawful authority of the Crown while he serves in the armed forces in Basra. If he commits a criminal offence, he will be charged and tried according to English criminal law, not Iraqi criminal law. If he has a tort claim, he must bring it in an English court. He cannot bring it in an Iraqi court. One of the features of this case is that Mrs. Smith could not bring any action for negligence against the MOD in any court in Iraq. An Iraqi court would not have jurisdiction over her complaint. Only a court in the United Kingdom has jurisdiction over her complaint. And if you ask the question, under whose jurisdiction was Private Smith, we submit the answer is obvious. He was under the United Kingdom's jurisdiction for all purposes. He was physically present in Iraq, but his legal relations were governed. His relations with his government were with the United Kingdom while he was there.
And you say you get this from customary international law.
Yes.
Lord Collins has referred to the rights of a belligerent occupier.
Yes.
But I think we're talking, aren't we, about the situation of
Active
Private
state.
Smith when he's not in the part of the territory being occupied? Aren't we talking about him in parts of the territory outside the base where he's on
My Lord, in my submission, it doesn't make any difference where he is. Whether he's on the base or out on patrol or at the fuel distribution centre.
What is the customary international law which authorises Private Smith to be out operating in Iraq would then be the question.
Yes.
And that's a
Yes.
rather difficult question, isn't it?
Well, I'm going to deal with it, though, my lord. I'm going to deal with it. The answer is that states which occupy other states are, of course, themselves must abide by the laws of war. But when they do occupy other states, their troops are under the jurisdiction of the occupying force.
We don't have the precise details, but I'd be surprised if the whole of the relevant area was not under belligerent occupation. It's not just the
Yes,
the
well,
base.
indeed. But I think Lord Mance was putting me the different point, which is that what was found in Al-Scani was that the whole of the relevant area wasn't under so much control that it could come within the Cyprus and Turkey principle of an area under effective control, which is, of course, a somewhat different question because you couldn't guarantee all human rights in the whole area.
Yes.
But I respectfully agree with your lordship. It would be under belligerent occupation. But the key point is not where he is, but what he's doing. Because what he's doing is serving Her Majesty as a member of Her Majesty's armed forces.
So on that approach, it doesn't matter how far they've got. It could be an expeditionary force that is just simply moving in.
He's always going to be under the jurisdiction
As soon
of
as
the
he
Crown.
gets into the overseas territory,
Yes.
he may not yet be an occupying force. He's just
No.
simply trying to establish a bridgehead or whatever you say.
But he is under the jurisdiction of the Crown.
Of course. But you're saying that gives more than that because you're... I'm trying to make the point that it's a given that he's under military law. That follows him wherever he goes.
course.
But it's the extra bit that I'm looking for.
But if he's out in the desert and he is shooting somebody, we've all agreed that that isn't an extraterritorial act, recognise it as constituting an exercise of jurisdiction. If he shoots an Iraqi, Al-Scani says, terribly sorry, that's not Article 1, not within Article 1. Well, then why is it any different if he's being bullied by his commanding officer in the desert?
The reason it's different is that the Iraqi who gets shot is an inhabitant of that territory, and ex hypothesi, even though that territory's been occupied, by a British force, the British don't have complete control over it. And in that situation, what the European Court of Human Rights has said, because they don't yet have sufficient control to guarantee rights in that area, they don't owe the obligations under the Convention to everyone in that area. Their de facto control, if you like, of that area has not progressed so far that they're obliged to guarantee Convention rights. But the soldier situation is different. When the soldier is bullied by his commander, that is an abuse of the governmental authority, the sovereign power, which his commanding officer has over him because of his status in the hierarchy of the army. And it's part of the sovereign acts of the United Kingdom to control, discipline, and guarantee the welfare of troops. And I'm going to show the court authority on that point as well.
But I think I'm right in saying it's not part of your argument that the British forces, having gone into Iraq, are guaranteeing the entire convention rights to all the population of Iraq. You're not saying that at all.
No,
you're saying they carry with them for their own protection.
Yes.
It's for their own protection.
Against their officers
against
or their colleagues.
Or their government, whoever else.
Yes, or the MOD.
There is actually a uniformity between the military law and the protection in that sense.
Yes.
That military law they have to obey. At the same time, you're saying, well, that's one side of the bargain. The other side is that they carry with them the convention rights wherever they are.
Yes, my
I
lord.
think that's what
that
you're
is,
saying.
my lord. And we say otherwise, one encounters some very odd legal anomalies. Because, as we shall see, the whole of English criminal law follows these people abroad. And of course, when they're within the jurisdiction of the Convention, that law must be interpreted in accordance with the Human Rights Act. But it must be the case of the respondents that when they're outside the base, even though they're subject to the same English criminal law, it doesn't need to be interpreted in accordance with the Human Rights Act because they're outside the jurisdiction of the Convention. And it's when you start examining those kinds of legal problems that my submission, the fallacy becomes apparent. And the reason it's apparent is these people are under the jurisdiction of the British state. They're governed by British law, and that includes the Human Rights Act.
Well, they're governed by the bits which operate, extraterritorially. Is that right?
Well, of course, the conclusion in Al-Skani is that the Human Rights Act does.
I'm not disputing that, but they're under the
Yes.
the bits which apply extraterritorially. Not all
Yes.
of English law does.
But the whole of English criminal law applies extraterritorially to members of the armed forces.
Yeah.
Well, I don't suppose road traffic acts do they?
I think... Well, we'll look at the
Provide an
statute.
example.
My lady, we'll look at the statute, and it is in extremely wide terms. So we were at paragraph 73 of Bankovich, and in my submission, that's the crucial paragraph, which is not simply saying consuls, diplomatic agents, and registered vessels are an exception from the prohibition on extraterritorial jurisdiction. What it's saying is they are situations in which customary international law and treaty provisions have recognised the extraterritorial exercise of jurisdiction by the relevant state. And it must follow from the court's reasoning in this case that other situations in which customary international law and treaty provisions have recognised the extraterritorial exercise of jurisdiction also fall within the scope of Article 1, because the court has already found that Article 1 is to be construed in accordance with the normal meaning of the term jurisdiction in international law. And we see the same approach expanded on, to some extent, in the admissibility decision in Al-Sadoun. Paragraph 85. Tab 44 in the same bundle. Paragraphs 84 onwards, the court's assessment. With perhaps a slightly touching optimism, Mr. Eady said how wonderful it was to have a case thoroughly in his favour. With great respect to him, this case is directly against him. but he didn't show the court the paragraph which is relevant. And that paragraph is paragraph 85. He showed the court paragraph 88, but it's paragraph 85 that is the relevant part.
I think we saw it.
Perhaps I'm doing him a disservice. In keeping with the essentially territorial notion of jurisdiction, the court has accepted only in exceptional cases that acts of the contracting states performed or producing effects outside their territories can constitute an exercise of jurisdiction by them within the meaning of Article 1. One example is Drozdh, cited above, where the court accepted that the responsibility of contracting states could in principle be engaged because of acts of their authorities, such as judges, which produced effects or were performed outside their own territory. The court has also held that when, as a consequence of lawful or unlawful military action, a contracting state exercises effective control of an area outside its national territory, there may be an obligation under Article 1 to secure the Convention rights and freedoms within that area. There are additionally other recognised instances of the extraterritorial exercise of jurisdiction by a state, such as cases involving the activities of its diplomatic or consular agents abroad and on board craft and vessels registered in or flying the flag of that state. In these specific situations, customary international law treaty provisions have recognised the extraterritorial exercise of jurisdiction. So that's all the same as Bankovic. But what we then have is some cases cited. X and Germany, X and the UK, and WM and Denmark. And if we go to X and Germany, this, I believe, is one of the new authorities that was handed up this morning. I don't know where your lordships and your ladyship will have filed it.
It's not one of the loose ones, I don't
No.
It was a loose one that was produced this morning.
Yes, it is. Yeah.
X and Germany, application 1611 of 62.
Yes.
Oh, yeah.
And the facts of this case are somewhat bizarre. But the principle, the relevant principle, is at the back of the decision. It's at page 168. The second indent. Whereas in certain respects, the nationals of a contracting state are within its jurisdiction, even when domiciled or resident abroad, whereas in particular, the diplomatic and consular representatives of their country of origin perform certain duties with regard to them, which may in certain circumstances make that country liable in respect of the Convention. Now, my learned friend sought to ridicule an argument based on the question of personal jurisdiction in relation to nationals abroad by reliance on his indivisibility of rights argument. So he said it would be absurd if, because there were some respects in which the British government could exercise jurisdiction over an expatriate national, that it meant that that national backpacked all his human rights to the marketplace in Rangoon. That was his argument. But of course, my lords, that is inconsistent with this passage, which is making it clear that there are indeed circumstances in which states exercise extraterritorial jurisdiction over their nationals abroad, which will be sufficient to bring them within Article 1, and that those are not situations in which the state then becomes obliged to guarantee the whole package of convention rights to that national, because what is said is perform certain duties which may in certain circumstances make that country liable in respect of the convention.
What was actually happening here?
This was complaints about visas, in fact, and refusals of visas. The facts are quite bizarre. And it was also said that we were seeking to resurrect old cases which had been laid to rest.
Sorry, I'm sorry, this is just
Yes.
to see what was going on.
Yes.
The argument of page 162, 164 was ranging over Article 3, Article 5, Article 6, Article 8, Article 12, Article 14.
Under the heading the law at 166,
Yeah.
Well, it's a penultimate whereas at the very end of the case,
yes,
which is Article 3 or Article
Yes.
8. What it's saying is that the failure to perform certain duties may engage the responsibility of the state for breaches of the convention. Not that the mere fact that there's a diplomat or a consul there will guarantee all rights under the convention.
precisely, my lord. That's precise, my lord. Now, it was suggested
that's
that...
the case I mentioned in
Yes.
Alskane is one of those which involves the activities of embassies and consulates, which subdivide into those where their activities concern nationals, this is one, and those where they're
Yes,
concern non-nationals.
That's right. And my point, my lord, is twofold. Firstly, that there's no suggestion that because certain extraterritorial exercises of discretion in relation to certain rights are being carried out here, bringing this individual within the scope of the convention, there's no suggestion that means that they're obliged to guarantee all of his convention rights, the whole package. There's no backpacking of the right to freedom of expression to the marketplace of Rangoon. That's the first point. The second point that I make is that Mr. Eadie said that we were seeking to resurrect dicta in old cases that had been, as it were, rendered redundant by the decision in Bankovic. But here, the court can see that this case is being expressly referred to by the court in Al Sadoun, a case on which my learned friend relies, after Bankovic, as authority for the general proposition that was set out at paragraph 73 in Bankovic.
But I mean, unless you can say that a soldier senior to the putative complainant asserting asserting rights pursuant to Article 1, unless you can say his senior officer is akin to the consul here in exercising UK jurisdiction in respect of some relevant aspect of governmental functions, there isn't the parallel. You've got to say that there is. You've got to say that the senior officer is towards his soldier is just like this consul towards the British citizen.
Well, it's more fundamental. The senior officer, yes, certainly, and also, of course, the Ministry of Defence.
Well, I mean, it doesn't matter which it is for this.
Indeed.
Purpose.
But that, my lord, we do precisely say that. We do certainly say that.
Does this case indicate that my Roma rights example was a bad one? Because actually it indicates that the jurisdiction spoken of in relation to diplomatic and consular representatives exists over nationals of their contracting state.
Well, this is an instance of nationals, but the same principle would apply if extraterritorial jurisdiction were being exercised over non-nationals.
Yes, but it wouldn't be normally. I mean,
was the Liechtenstein case a national or a non-national?
That was a non-national. The Liechtenstein case was indeed a non-national.
Which is an example of this sort of thing.
Yes, he was not a national of Switzerland or Liechtenstein, and that's why he was being prevented from entering both of those countries by an action of the Swiss authorities.
B, Lord Philip's case, the Australian, that was a non-national too.
Absolutely not, yes.
But that was a territorial case, B, wasn't it?
Well, there has been some attempt to analyse the consul cases as if the embassy or the consulate were a little England. But my submission is that that's not actually the reasoning that you find in any of these Strasbourg cases. None of them are looking at where the activity happened. What they're looking at is the nature of the power that was being exercised.
I mean, presumably consuls go and visit people in hospitals and so on and so forth.
Yeah.
Yes, well, Lord, one of the cases we're going to look at in a moment is the child who goes missing in Jordan. So making inquiries, not necessarily sitting in the consulate.
This means, does it, that any individual who applies to one of our representatives abroad for permission to enter this country is entitled to assert Article 8 rights under the Convention?
My Lord, if they fell, if a governmental power was being exercised, yes, they
Well,
could.
that's exactly
Yes.
what it is being.
Well, that's the Roma rights case, which of course was in Prague Airport.
And my recollection is that's been taken for granted in the odd
Well, certainly
immigration
Strasbourg.
case that we've had, where Article 8 rights are being asserted, for example, by children trying to join sponsors who are their de facto parents here.
And another case where I believe it was taken for granted is the Carson case, where you're talking about expatriate pensioners living in Australia and...
Do we know what happened today?
No, not yet.
They were giving judgment today.
in Carson?
Yeah,
Oh, I
giving
didn't know.
Well,
It's a pensions.
yes, in the
I didn't know
pensions
that.
case,
Pensions from
yeah.
Canada. There was a Canadian, I think, who was...
I didn't know that.
At lunchtime, I couldn't...
I think they upheld the decision of the
I'm told that,
UK.
yes, it was, I'm told that the UK won.
Oh, right. That's
The
why I
UK
didn't
one.
get onto the news.
But I don't think it was
Not on
suggested
jurisdictional
that the
grounds.
pensioners were not within the jurisdiction, even though they were, sitting in Canada or Australia. And yes, Ms. Simon reminds me rightly that in Abdul Aziz, of course, the classic Article 8
Yeah.
case, that the family were outside the United Kingdom, but not outside the jurisdiction.
Yes. And the consul abroad doesn't have to guarantee their freedom of speech.
No, or their right to marry. Yes. East African nations, of course, is another very important case in that regard.
But all these ECOs are abroad anyway, aren't they?
Well, yes, no. But so that is X and Germany. There is then X and the United Kingdom, which is the case I've just been referring to, which is dealing with Jordan. That's in volume 12 of the authorities bundle at tab 104. And again, the court will note this case expressly referred to in Al Sadoun, in the passage we've just been looking at paragraph 85. So not resurrecting an old case, this case being referred to recently by the court.
I'm sorry, this case expressly refers to what?
Al Sadoun, paragraph 85, top of page 39. We've looked at X in Germany.
Yeah.
And the next case, you'll see there's X in the United Kingdom, 7547 of 76.
Yeah, we got that. Tab
And
one.
that's the one we're looking at now,
Yeah,
which is tab 104
Yeah.
in volume 12.
yeah, no, I got that.
So my point is that, again, this case expressly referred to by the court in Al Sadoun and being applied.
I see.
And we can see the facts here, that the applicant was a British national. She'd married a Jordanian citizen. They had a daughter. Father took the girl to Jordan, returned without her. English court granted custody of the daughter, issued a committal order against the father, requiring him to return the girl to the United Kingdom within 3 weeks. The applicant required a Jordanian court to grant her custody. Her claim was dismissed in absentia. Father left for Jordan. He has not come back. The applicant got in touch with the British consulate in Amman, asking it to obtain the custody of her daughter from the Jordanian court. Consulate reported on the child's well-being, provided her with a list of lawyers practicing in Jordan, and registered her daughter in her passport. And then we see the law. The applicant complains that the health of her daughter has not been protected due to the failure of the British consul to intervene in her domestic dispute, help unite mother and child. She complains, therefore, that there has been a violation of the right for her and her daughter's family life and home. So, claiming a violation of her right, she being in the United Kingdom, and her daughter's right, her daughter being in Jordan. And the consul, of course, being in Amman. In the second paragraph, the applicant's complaints are directed mainly against the British consular authorities in Jordan. It's clear in this respect from the constant jurisprudence of the Commission that authorised agents of the state, including diplomatic or consular agents, bring other persons or property within the jurisdiction of that state to the extent that they exercise authority over such persons or property. Insofar as they affect such persons or property by their acts or omissions, the responsibility of the state is engaged. And then they find that they're within the jurisdiction, but in fact they've done everything that was reasonable, so there was no breach. And the court will see that the authority cited in this case for that proposition is, first of all, 1611 of 62. That's the case we've just looked at, the German case. And secondly, the case of Cyprus and Turkey. There are so many Cyprus and Turkey cases, but this is applications 6780 of 74. And that case is in volume 6 at tab 57.
I'm sorry, who refers to this case?
This case is referred to in X and the UK, which itself is referred to in Al Sadoun.
I see. Yes,
So Al Sadoun refers to
I
X
see.
and the UK,
I got it.
and X and the UK refers to Cyprus and Turkey as authority for the proposition for which it is cited in Al Sadoun. So then we go to that. Tab 57. But before we look at it, of course, just before we leave the Jordan case, cannot fit with their limiting principles of full package of rights or espace juridique, because it's talking about Jordan and it's talking about a situation in which the consul only had very limited ability to assist in relation to certain rights. So then we come to Cyprus and Turkey, and it's paragraph 8 on page 136. You can see at 7 the submission. The respondent government further contend that the Commission has no jurisdiction, ratio loci, to examine the applications insofar as they relate to alleged violations of the Convention on the island of Cyprus. They submit that under Article 1, the Commission's competence, ratio loci, is limited to the examination of acts alleged to have been committed on the national territory of the high contracting party. Turkey had not extended her jurisdiction to Cyprus, cannot be held liable. In Article 1, the high contracting parties undertake to secure the rights and freedoms to everyone within their jurisdiction. Sorry, paragraph 8, just invite the court to, page 136.
You were reading paragraph 7 a moment ago.
Yes, we looked at paragraph 7.
Yes, we've looked at this.
Yeah. But the second paragraph of paragraph 8 is the crucial bit. The Commission further observes that nationals of a state, including registered ships and aircrafts, are partly within its jurisdiction wherever they may be, and that authorised agents of a state, including diplomatic or consular agents and armed forces, and I stress and armed forces, not only remain under its jurisdiction when abroad, but bring other persons or property within the jurisdiction to the extent they exercise authority over such persons or property.
We've seen this quoted before.
Yes.
Yes. And
Where did we see it?
we saw it quoted before.
This was in the passage
Yes.
that was
Al
said to be
Sadoun
rather
Court
too
of
broad,
Appeal.
wasn't it?
Yes. Now,
Ms. Treaty was referring to that and said it was regarded as too broad.
yes. Now, can I just make a submission on this point? The part that's too broad, following the decision in Bankovic and consistently with the court in Al Sadoun, is the last part, where it says, bring any other persons or property within the jurisdiction of that state to the extent that they exercise authority over such persons, insofar as by their act or omission they affect such persons or property, the responsibility of the state is engaged. So the suggestion that an authorised agent of the state, such as a member of the armed forces, can bring a person within the jurisdiction of the state simply because of the acts that they do in relation to that person, that I absolutely accept is too broad in the light of the restrictions imposed by Bankovic to the notion of effective control of a territory. I accept that. But that qualification does not affect the earlier part of this paragraph, and in particular the point that authorised agents of a state, including armed forces, remain under its jurisdiction when abroad. That point is entirely unaffected by Bankovic and is simply, in my submission, a statement of a recognised principle of international law. So if the question is asked, where is the authority that establishes that members of the armed forces remain under the United Kingdom's jurisdiction when they are abroad, the answer is here it is.
Is this the high point of the argument in terms of actual explicit authority for your proposition?
Well, my lord, this case is referred to in other cases of the European Court of Human Rights, including in Drozd. If we go to Drozd, that's in volume 7.
Well, while my learned friend is going there, this passage was referred to in paragraph 135 of the Divisional Court's judgment in Elskane. Yes. That's where you've seen it before, I think. I took you...
Sorry,
135 of the Divisional Court's judgment in tab 2 of the White Bundle.
It might be an idea to turn that up.
So not by the Court of Appeal?
No, the Divisional Court.
Yeah.
And the bit that you said was too broad,
Yes.
you say is correct in relation to diplomatic or consular agents too?
Well, no, my lord, it might be too broad in relation to consular agents. It wouldn't be sufficient simply that... sorry, I've managed to lose the place now. If
Well, to the extent that they exercise authority over third
or
parties.
to the extent that they exercise control over such persons or property, that wouldn't be sufficient. If a consular agent simply impounded somebody's goods, that wouldn't be a breach of that person's Article 1 First Protocol rights by the United Kingdom state. My submission is that it is only in a situation where the consul is exercising a governmental power that he can bring somebody under the jurisdiction.
Sorry, just complete what you were going to say.
Yes, I was going to draw the analogy with armed forces, that if you have simply a use of force that causes somebody injury, that isn't going to be sufficient without more to engage the jurisdiction of the state.
The whole of this passage is under the heading, as the Commission's competence, ratione loci.
Yes.
And that's what it's dealing with.
Yes.
So it's just an aside that you rely on, isn't it?
Well, no, my lord, the competence ratione loci is the question of jurisdiction under Article 1. Because as we saw...
Aren't you just relying upon not only remain under its jurisdiction when abroad?
Yes.
So that's an exception to jurisdiction ratione loci.
Yes. Well,
But
it's an extension.
that's just a toss-away sentence when what they're really focusing on is
that they
the
can bring
extent to
others.
which there is control over Northern Cyprus and the extent to which that gives jurisdiction.
Well, they are, in that case,
Yes.
addressing the interaction between the Turkish forces and the local population. That's
Yes.
right.
Yes.
But the starting point for that is that those forces, like the consular agents, remain under the jurisdiction of the sending state. And that's why my submission has been that our case isn't an extension of the principles in Bankovic. It's simply a recognised underpinning of the sorts of situation that were recognised in Bankovic and in the earlier cases, because it's not disputed that states retain jurisdiction over their forces that they send abroad. And with respect, the radical proposition is the proposition for which my learned friend is contending. First of all, that jurisdiction under Article 1 means something different from jurisdiction in international law generally. And secondly, that the armed forces of the United Kingdom, when on active service overseas, are not under the jurisdiction of the United Kingdom. That, in my submission, is a truly radical proposition.
Was that last part of paragraph 8 too broad? Because when you look at paragraph
Yes.
10, the whole point of the case was what we see, the conclusion.
I'm sorry, I've moved on. Can
I'm
you
very
also
sorry.
give me the
It's-
reference again?
It was volume 6, tab 57. And you were saying, I think, that
Yes.
that
Paragraph 8.
that the second half of the second
paragraph
paragraph of
8
paragraph
was
8
too
was too
broad.
broad.
Yes.
Really reading from the words after when abroad.
Yes.
But the important point, surely, is to read on to paragraph 10, second indent of paragraph 10, which is explaining why Turkey's responsibility does extend to, they bring other persons or property in Cyprus within the jurisdiction of Turkey in the sense of Article 1. Even although there's been no annexation, the fact is that they're there, exercising control, and therefore third parties are brought into the protections of the Convention.
Yes, but my lord, what I would accept is that in Bankovic, the breadth of the principle as it's stated in the second part of paragraph 8 is limited by the wording of Bankovic. And what is said is it's not enough to say that because they're authorised agents of the state and they are, by their acts or omissions, affecting persons or property or controlling them, that's enough for jurisdiction. I accept that's not enough.
Well, it is enough for the particular category that's being dealt with in this case, which is the espace of the member states, isn't it?
Well, no, my submission, there would have to be more, because it's in that context that I accept that the notion that they are exercising sufficient of the public powers of government to be able to guarantee a full package of rights, that does become relevant. Mm-hmm. That is relevant to the court's analysis. Mm-hmm. And that essentially, in my submission, is the ratio of Alskany. That it's the distinction between having some personal control over a person and having sufficient control for the Bankovic principle of effective control over an area to be engaged. That's the distinction that has arisen in the case law. But it doesn't affect the basic principle that we contend for.
I mean, just before you leave this, with the first part of the second paragraph in paragraph 8,
yes.
Is that just slightly wide? I mean, nationals, I mean, hard to imagine that all British citizens, wherever they may be, are within the jurisdiction for the purposes.
Yes.
Sorry, you've lost me.
Just sorry, paragraph 8, Ms. Rose.
Yes.
Second.
The second part of
yeah, it's just the opening part where it says
nationals of a
state, wherever they may be.
Yes.
It says partly within its jurisdiction.
Yes.
It's hard to see that in any relevant sense for the. I mean, that really would be backpacking the.
Well,
right.
Unless one understands it simply in the sense that I've indicated, that where, for example, you have legislation like pensions legislation that affects them, that convention rights will apply.
But you have to do something.
You have to, yes. But yes, that's right. Yes. But where they are affected by exercises of governmental power from the United Kingdom, then yes.
Yes, but they're not just, it's not by virtue of simply being, I mean, there's no...
Not just by virtue of being a
national. There's no reason for Britain to try and ensure Article 10 rights for people living in Australia or something like that. That would be quite wrong.
Yeah. Now, my lords, the next point that I made was that this authority is explicitly referred to in Drojd. That's volume 6.
You don't think it's volume 6?
No, sorry, it's volume 7, I beg your pardon. Volume 7, tab 61. It's one of the authorities referred to in the notorious paragraph 91. What do you mean? No, it's not. It's the same case. It's the same case. So if the court looks, you can see sort of halfway through the list of references at 91, it refers to 6, 7, 80, 74 and 6, 9, 50, 75, Cyprus and Turkey, which is the case we've just been looking at. And in my submission, that's consistent with our contention that the Drojd type of situation is not really a different example or different exception from that for which we're contending. It's simply an instance of the application of the same principle. That if a French judge sits as a French judge and determines people's rights and obligations in the territory of Andorra, to that extent, he will be bringing those who appear in front of him under the jurisdiction of France, and they will be entitled to the protection of the Convention in relation to his exercises of authority. And we submit that's the same principle.
If he is acting as a French...
As a French judge, yes, absolutely.
Yes.
That's the crucial point, of course, that's the crucial point. And again, of course, a point on which we rely, that here the British forces are acting as the British forces subject to the Crown.
Well, you'd say that that same principle must have applied to the Scottish judge who tried the alleged Lockerbie bomber in the Netherlands.
Yes, indeed,
Judges.
we made an unsuccessful application to Strasbourg on behalf of the Lockerbie bomber, and I don't believe any extraterritoriality point was taken against us.
I think I mentioned
He was
that
thrown
case.
out for other reasons.
You did.
I think he did.
Yes, I think you did.
I think I mentioned it in Alsgate, didn't I?
Yes.
Yes.
But the same would have applied on your argument, whether it had been the Netherlands, which is within the espace juridique, or
Yes.
whether it had been
Libya.
somewhere else, New York.
Yes, absolutely. The point is, it's not territorial, it's about the exercise of power, about the exercise of governmental power. The Cyprus and Turkey case is also referred to, and the same principle is enunciated in the case of W and Ireland. That's Authorities Volume 12, tab 102. We don't need to turn this up. You'll see the extract set out at paragraph 88 of our printed case. It's to the same effect. The same principle. And still in our printed case, at paragraph 89, we've referred to some other cases where the Cyprus and Turkey case is referred to. Yeah, the same thing.
Is there any reference to armed forces in...
Yes,
Government
those are
Island?
all cases which specifically refer to armed forces remaining within the jurisdiction of the state when they operate extraterritorially. Those are all cases that mention that principle.
Yes, I see.
Sorry, which cases mention that?
The case is listed at paragraphs 88 and 89 of our printed case.
Well, I
So
suppose
they
in-
all use... I'm terribly sorry.
They all use the same words, yes, my lord.
armed forces exercising discipline over their own soldiers would be an example, wouldn't they?
Yes, indeed, my lord. And of course, there is the case of Martin and the United Kingdom, which was a case of a youth who was charged with murder. His father was serving on a British Army base in Germany, and they'd returned to the UK, but he was then sent back to Germany to face a court-martial. And there was no question of, there was no jurisdiction point taken by the United Kingdom in that case. There is also the case of X and Y in Switzerland, which is, of course, also referred to in Drost. I make the point in passing that Drost is a decision of the plenary court, which, as we've just seen, expressly endorses the Cyprus and Turkey case, including the reference to armed forces. X and Y in Switzerland, volume 12, tab 103. This is the Liechtenstein case. And it starts at paragraph 71. And just under paragraph 2, the Commission calls its earlier case law already established contractual responsibilities engaged insofar as they exercise jurisdiction outside their territory and thereby bring persons or property within their actual authority or control. The circumstance that the present case concerns facts in Liechtenstein does not therefore necessarily exclude the Commission's competence to their application. However, the responsibility of Switzerland under the Convention can only be engaged if the measures of which the applicants complain are imputable to Switzerland rather than Liechtenstein. Liechtenstein is a sovereign state which has not ratified the Convention. It is clear that the Convention is not binding upon the Liechtenstein authorities themselves. In the present case, however, it is exclusively the Swiss authorities which have acted, although with effect, in the territory of Liechtenstein. The Swiss authorities exercise their functions on the basis of the treaty relationship between the two parties. Then they go through the treaty, and then at page 73, what matters in the Commission's opinion is the circumstance that, according to the system established by the above agreement, a prohibition of entry pronounced by the Swiss authorities, while producing its effect first of all in Swiss territory, is automatically extended to Liechtenstein by virtue of Article 3, and the Liechtenstein authorities themselves have no possibility to exclude this effect. Switzerland is certainly responsible under Article 1 for the procedure and for the effect which the prohibition of entry produced in its own territory, but it must also be held responsible insofar as the prohibition of entry produced an effect in Liechtenstein. According to the special treaty relationship, Swiss authorities, when acting in Liechtenstein, do not act in distinction from their national competences. And we submit that's a further instance of the basic principle for which we contend, that here, by virtue of a specific treaty, the Swiss authorities are performing public governmental acts which have effects on people's rights to enter Liechtenstein. And that's a classic exercise of jurisdiction extraterritorially. It has nothing to do with effective control of an area, has nothing to do with the indivisibility of rights. Switzerland have no power to guarantee any other rights in Liechtenstein except that right.
I mean, ought we to be surprised that there isn't a case where any, so to speak, any soldier abroad has asserted against his government convention rights, and this point's arisen for consideration?
Well, there are cases where people have asserted rights, but where the jurisdiction principle had to be taken. And Martin in the UK is an example of that. Now, the applicant in Martin wasn't himself a soldier, he was the son of a soldier.
Why?
But he was subject to military law because he was the son of a soldier. And no point was taken on jurisdiction based on the fact.
Sorry, no point taken by who?
By the United Kingdom government, based on the fact that the court martial took place in Germany.
Is Martin in the bundles?
But I mean, what point would they have been taken?
Well, that it was an extraterritorial question, that they weren't guaranteeing the full package of rights in Germany, that they didn't have effective control over the whole of the territory of Germany, and therefore there's no jurisdiction. The same argument they run in this case. And as soon as one examines it, one sees that it doesn't run.
But I'm wondering why there isn't a case where some individual has said, now look here, I'm abroad on Her Majesty's business, and I say if something's happened to me abroad that engages my convention rights. I mean, but there hasn't been such a case.
Well, the Martin case is such a case. He was complaining of a breach of his Article 6. He was complaining of a breach of his Article 6 rights.
Okay, so where do we see Martin?
Yes, so.
It's volume 979.
There's no issue taken in this case about jurisdiction, but as your lordships can see from the analysis of the facts, he was in Germany with his father, this is paragraph 11, His father was a corporal. He was charged with murder. He was subject to military law. The German authorities waived jurisdiction pursuant to the NATO Status of Forces Agreement. So this is a case where the Status of Forces Agreement applies. So there are arrangements as between states, because the British forces are present in Germany with consent. There are arrangements to govern questions of jurisdiction. He is then returned to the United Kingdom, and then he is still subject to military law, and he's sent back to Germany, as we see at paragraph 15, and subjected to a court-martial. And he complained about a breach of Article 3 and also a breach of Article 6 in relation to the way that the court-martial was conducted in Germany. Complained against the British authorities. And there was no suggestion that they didn't have jurisdiction, and in my submission, rightly so, because it's obvious that they retain jurisdiction over their own troops. And that's why I submit that what's radical is the fact that they take this point in this case. Can I now turn...
It was a statutory procedure, wasn't it?
Yes, it was, my lord.
So, I mean, the most that he could have hoped for was a declaration of incompatibility.
Yes. Now, can I now turn back to Bankovic and...
Well, yes,
Sorry.
I'm just looking to see on the timing of this. It reached the House of Lords before the Human Rights Act came into force, didn't it?
Yes.
Yes, but the decision was in 2006.
Yes.
Yes.
What? So the court-martial was
Yes.
pre-years.
Yes.
My lords, can I now turn back to Bankovic and examine the limiting principles on which my learned friend seeks to rely, the principle of indivisibility and espace juridique. So we're now back in volume 5, tab 47. Paragraph 75.
Where have we gone?
Paragraph 75. Bankovic.
Oh, bankruptcy.
Tab 47 in volume 5. And here we see, very importantly in my submission, how the applicants in Bankovic were putting their case. In the first place, the applicants suggest a specific application of the effective control criteria developed in the Northern Cyprus cases. So that's the first point to note, that that's the principle that they were relying on, the effective control principle, which we submit has nothing to do with this case. They claim that the positive obligation under Article 1 extends to securing the Convention rights in a manner proportionate to the level of control exercised in any given extraterritorial situation. So just pausing there, their argument was where any degree of control is in fact exercised by a state outside its territory, then to that extent, the individuals who are adversely affected can rely on their convention rights. That was the argument.
That's really what the majority found in the context of Council of Europe in Moldavia.
Well, my lord, no, well, Moldova is a different point, because Moldova, in my submissions, supports my point, which is that in Moldova, the state had legal jurisdiction over the territory, but wasn't able to exercise factual control. And the court says in that situation, you're under the jurisdiction of the state. And that's directly comparable to my point, which is where the state's exercising legal jurisdiction, then that is sufficient to engage Article 1. You don't have to have the ability to deliver the full package of rights. And the point I'm making is that a different principle was being relied on by the applicants in Bankovic, not based on the exercise of legal authority or jurisdiction in the legal sense, but simply de facto control, based on the, of course, unlawful as a matter of international law, occupation by Turkey of Northern Cyprus, and the principles derived from that factual situation. And they were saying, insofar as any state, in fact, has control over anybody outside its territory, to that extent they must guarantee the Convention rights. And that, of course, is a pretty radical extension of the notion of what jurisdiction is. And they're using it to say, because they had the power to hit us with an airstrike, therefore they had the duty to protect our lives under Article 2. And that's why we see in the next sentence...
Which paragraph now?
We're still in paragraph 75. The governments contend, this is immediately after what we've just looked at, the governments contend that this amounts to a cause and effect notion of jurisdiction not contemplated by or appropriate to Article 1 of the Convention. In other words, the governments are saying, you can't say, just because you've had an adverse effect on me, that therefore I fall within your jurisdiction. And they then go on, the court considers that the applicant's submission is tantamount to arguing that anyone adversely affected by an act imputable to a contracting state, wherever in the world that act may have been committed or its consequences felt, is thereby brought within the jurisdiction of that state for the purpose of Article 1 of the Convention. And we submit that's the crucial point about Bankovic, that the argument being mounted by the claimants in that case would have emptied the concept of jurisdiction of any significant content. Because whenever a state was in a position to violate your rights, it would have followed from the claimant's argument that you were within their jurisdiction. And then the court goes on to say that it's not inclined to agree with the government's submission that Article 1 does not accommodate such an approach it is inclined, to agree that it doesn't accommodate such an approach. And then at the top of page 22, the applicant's notion of jurisdiction equates the determination of whether an individual falls within the jurisdiction of a contracting state with the question of whether that person can be considered to be a victim of a violation. These are separate and distinct admissibility conditions. Then the espace juridique point is developed at paragraph 80.
I'm sorry, going back to 75, the point the court makes about not dividing and tailoring is in the context not of jurisdiction but of acts, isn't it?
Yes, my lord. Sorry, I managed to miss the most relevant bit. The point that the court is making at paragraph 75 in relation to divided and tailored is that if your complaint is based on control, you can't, it's not enough to say they could do something bad to me, therefore I'm within their jurisdiction. You've got to show that the control is sufficient for them to be in a position to guarantee all of your rights. So it's specifically in the context of a situation in which the basis for jurisdiction is said to be effective control, not the exercise of legal authority. And that brings us back to the Moldova point, that if it is legal authority, it doesn't matter if it's effective control. So that's the point at 75. Then the point at 80 is the espace juridique point. And in particular, the last paragraph on page 23, in short, the Convention is a multilateral treaty operating subject to Article 56 in an essentially regional context, notably in the legal space of the contracting states. The Federal Republic of Yugoslavia clearly does not fall within this legal space. The Convention was not designed to be applied throughout the world, even in respect of the conduct of contracting states, Accordingly, the desirability of avoiding a gap or vacuum in human rights protection has so far been relied on by the court in favour of establishing jurisdiction only when the territory in question was one that, but for the specific circumstances, would normally be covered by the Convention. Now, in my submission, all that they're saying is that the desirability of ensuring that there's no vacuum in rights protection is a factor relevant to the question whether there is jurisdiction, and it will be particularly relevant in a case such as Northern Cyprus, where you had a state that previously was protected by the Convention, which is then occupied by another power which itself is a signatory of the Convention, and in that situation it's a factor in favour of saying that the state that has occupied is itself under obligations to respect the Convention. That's all that's being said. It's simply, as the court says, it's been relied on by the court in favour of establishing jurisdiction. There is no suggestion that there is any bar or obstacle to the establishment of extraterritorial jurisdiction in circumstances where a state is exercising jurisdiction outside the area of the Council of Europe.
I'm getting a bit lost, I'm sorry.
I'm sorry, my lord, it's getting a bit late. The point I'm making is that at the most, this point about the legal space is only a factor in favour of jurisdiction where it applies. So that if you're establishing a case of jurisdiction based on effective control, the fact that the area in question is inside the legal space of the Council of Europe will be a factor in favour of saying that there is jurisdiction. That's all, because of the desirability of avoiding a vacuum in that situation. But they're not suggesting that if you're outside the legal space, there can't be jurisdiction. And indeed, they couldn't be taken to say that. It would be obviously inconsistent with their decision in Al Sadoun if they were to take that position, because Al Sadoun itself is outside the legal space of the Convention. It's about events in Iraq.
But they're still saying, aren't they, in the second last sentence on page 23, that the Convention was not designed to be applied throughout the world, even in respect to the conduct of contracting states.
Yes, indeed.
So one has to be a bit careful.
Yes, but of course that is, again, a comment in the context of effective control. It's not...
Please, continue.
Sorry. My Lord, it's not a comment made in the context of legal exercise of authority. It's only where you're seeking to establish jurisdiction on the basis of occupation of your territory.
The essence of this case is that acts abroad or conduct abroad or acts which are imputable to the state don't necessarily are not necessarily within the jurisdiction committed within of that state.
Yes, my Lord. Yes, my Lord. And of course, as the court has already seen, there are many cases where extraterritorial jurisdiction has been found outside the Council of Europe area. Al Sadoun is one example. The Jordan UK case is another example. Öcalan and Turkey is another example.
Al-Skani is an example.
Al-Skani, of course, is another example. There are many examples. So we submit that this principle takes my learned friend with respect nowhere. That then brings me to Al-Skani, and that's in volume 2, tab 21. And if we go first to the speech of Lord Roger, at paragraph 64. This is the point about the jurisdictional link. And, my Lord, we accept that all that is being said in this paragraph by Lord Roger is that there has to be a jurisdictional link between the state and the victim, and that Lord Roger is not identifying what that link must consist of.
You accept the Court of Appeal placed rather too great emphasis and reliance on it?
Well, the Court of Appeal's judgment falls into two parts. There is certainly the first part, which, with respect, perhaps places a little too much reliance on that, but they then go on, in my submission correctly, to consider the specific exceptions to the territorial limitation on jurisdiction in Bankovic. Yes, so perhaps...
Well, in the first part, they were really, to be fair, misdirecting themselves as to what exactly was being meant by link, and they were finding a link there which really wasn't contemplated by this passage at all, was it?
Well, that may well be right, my Lord, and of course it makes very little difference, since the question is what the right answer is and not whether the Court of Appeal expressed themselves correctly. So just having a look at what Lord Roger does decide here, he then, at paragraph 65, poses the question what is meant by within their jurisdiction in Article 1. With respect, the right question, and not a question that my learned friend, Mr. Eadie, has sought to give a clear answer to, and says that that's a question of law, and that the body whose function it is to answer it definitively is the European Court of Human Rights. And he then goes on to say that the Strasbourg view is definitive and that it is Bankovic which is the authoritative case, and that's paragraphs 65 to 68. So on that basis, the task for this court remains the same task that was before the House of Lords in Alscaney, which is to interpret the case law of the European Court of Human Rights, including, crucially, Bankovic, but also later developments, and we submit, importantly, Al Sadoun. And your Lordships already have my submission about the somewhat different light that is thrown upon Bankovic by a case such as this, which is not concerned with effective control at all, but concerned with the exercise of legal jurisdiction. So then at paragraph 70, and this of course in the context of Alscaney, which was an effective control case, and the question in Alscaney was whether there was sufficient control over those who were not within the base. That was the question. At paragraph 70, there is examination of the Bankovic submission, and then Lord Roger goes on to look at Issa and identify the difficulties in reconciling Issa with Bankovic. Then at paragraph 78, Lord Roger considers the essentially regional nature of the convention and says it's relevant to the way the court operates, has judges elected from all the contracting states, not from anywhere else. And then there is the point over the page that the result is a body of law which may reflect the values of the contracting states, which most certainly does not reflect those in many other parts of the world. So the idea the UK was obliged to secure the observance of all the rights and freedoms interpreted by the European Court in the utterly different society of southern Iraq is manifestly absurd. And we respectfully don't disagree with any of that. But we submit that it doesn't have any application to this case because it is not manifestly absurd to suggest that the convention rights should be guaranteed to British troops who are resident in the United Kingdom and who are in Iraq only because they are on active service for the Crown. There is no absurdity at all in giving them the protection of the Convention when they remain subject to the rest of United Kingdom law.
You would apply the same argument to the consular agent,
Yes.
grossly abused one of the consular employees.
Yes, absolutely. And then at paragraph 79, Lord Roger deals with the indivisibility of rights point. And just opposite E, the whole package of rights applies and must be secured where a contracting state has jurisdiction. Now, we do respectfully say that that is a statement which in the context of Alskaney is correct, but if read in isolation, with respect, goes too wide, because there are circumstances in which there may be jurisdiction without the whole package of rights being guaranteed.
All the embassy cases.
All the embassy cases, indeed. Then coming on to Lord Brown, paragraph 109, where Lord Brown sets out certain central propositions for which Bankovic stands. Now, the first we accept, entirely correct. Then, still under paragraph 1, there is the essentially regional context, and your lordships have my submissions on that. Then there is the point about Article 1 jurisdiction to avoid a vacuum in human rights protection, where the territory would normally be covered by the Convention. And again, we submit absolutely right in the context of Bankovic, but not a reason for precluding jurisdiction in a case where there is complete control or in a case where there's a lawful exercise of jurisdiction. Then at 3, there is simply the statement, the rights and freedoms defined in the Convention cannot be divided and tailored, and I make the same submission in relation to that as in relation to Lord Roger, that on its face, with respect, somewhat too wide. Then at 4, quotations of the examples, that's the effective control example, exercise of public powers, and then just below the letter E is the reference to diplomatic and consular agents, and then the reference to droit. And my submission is that in reality those two categories are not different, they are simply instances of the same principle. And we see a similar analysis from Lord Brown at paragraphs 121 to 122. And Lord Brown comments at the end of 122, it is unnecessary for present purposes to consider the facts of any of them. And I respectfully agree, because of course Alskaney was a case which didn't engage the circumstances that apply to that category of case at all. And then at 129, this is the divided and tailored point, which again in my submission, right in relation to effective control, but not generally in relation to other exercises of jurisdiction.
It also deals at the end with the possibility of conflict between the local law and convention rights, which again doesn't arise in this type of case.
Indeed, and my lord, I'm going to look in a little more detail at precisely what the legal situation was in Iraq in relation to British armed forces at the time. And in short, it was that the British authorities had exclusive jurisdiction over the activities of the British armed forces.
Is it worth noting paragraph 130?
It is, my lord. I was just about to point that out, which, of course, again, is consistent with our case.
Well, an apologetic way of explaining why you weren't troubled by indivisibility for those cases.
Well, I didn't think it was very apologetic, with great respect. I thought it was a perfectly sensible remark. That doesn't actually cause problems there, because one's got a limited idea, and it doesn't. You don't need to explore the principle to great depths in those particular cases. But can you say that the army cases are highly specific situations raising only a limited range of convention
No,
rights?
my lord, we don't say that. Indeed, our submission is going to be that, in fact, the United Kingdom is in the position to secure the convention rights to those serving abroad. When one considers, first of all, the inherent qualifications in those rights, including the qualifications in relation to the positive obligation under Article 2 relating to proportionality and reasonableness, and secondly, when one considers specific recognition by the Strasbourg Court that convention rights have to be modified in the context of military service. And there are two cases that I want to show to your lordships which make that point. So we submit that there isn't any difficulty on the facts of this case with the divided and tailored argument in any event. But we do also submit that even if you could identify a particular convention right that couldn't be secured in the context of Iraq to British soldiers, that would not prevent there being an exercise of British jurisdiction over those soldiers. Example, the Martin case. That the boy in the Martin case was under the jurisdiction of the Ministry of Defence and of the Armed Forces, even though in Germany there would have been many instances in which he fell within the jurisdiction of the German state. And if, for example, there were a German law prohibiting certain activities that would be lawful in Britain, he might be subject to that law.
I'm just contemplating the problem, which actually wasn't, I imagine, very realistic in Iraq, but soldiers off duty. You've been dealing with people in operational situations, and one understands what that is, but off-duty soldiers gathering in marketplaces or in the souk or wherever it is in one of these places, you can't guarantee to them, surely, the UK can't guarantee to them all the convention rights, can it? I mean, your argument has got got to stop somewhere. I mean, are you really saying that simply because they're subject to military law and military discipline, no doubt when they're off duty as well as on duty, therefore they carry with them the protection of all the rights wherever they wander about, off duty as well as on duty?
Well, my lord, there are a number of points contained in that. The first is the question of the substantive content of the convention rights in the context of soldiers who are on military service. And the point that I make is that they may have more limited entitlements. For example, their rights to freedom of expression or freedom of religion have been recognised by the court as being more limited than the rights of civilians. They may also be subjected to stricter disciplinary rules, which may be discriminatory as between officers and men, matters like that. So they may have more limited rights anyway. Now, my submission would certainly be that the United Kingdom is under a general duty to these soldiers while they are abroad on active service to guarantee them convention rights, but that means to do what is reasonable and proportionate in the circumstances.
Yeah. I think the expression guarantee is rather misleading in this context.
To
For example,
afford protection.
If an off-duty soldier
Absolutely.
is imprisoned by an officer of the Iraqi state, well, that is not down to the British government.
No. But of course, since he's immune from the jurisdiction of the Iraqi state, that would raise an issue about what steps the British government would have to take to get him out.
Yes.
Because there would be no lawful basis on which he could be imprisoned.
I mean, is your case the same as in respect of ambassadors, consuls, representatives of diplomatic service board? I mean, they aren't subject, as I would imagine, to the same internal disciplinary scheme. I don't know how long-arm criminal jurisdiction, all the rest of it. So, I mean, what's their position?
Well, my lord, we submit it's the underlying principle which is the same, which is that you have in this case, as in the consul's case, an exercise by the United Kingdom of governmental powers overseas. The nature of the governmental powers is very different in either case. In the case of the consul, it is specific powers to deal with visas, to deal with passports, to give aid and assistance to distressed British nationals. And in relation to those powers, the British consul exercises authority, comes into contact with, has authority over, in a governmental sense, British nationals, and has a duty to protect their convention rights to that extent. So that's one context. Our context here is an occupying military force which goes into Iraq, thousands of people, all of whom are absolutely subject to the legal authority of the United Kingdom, indeed of the sovereign, acting through the Ministry of Defence. And being in that situation and subject to the sovereign power of the United Kingdom, following the orders of the United Kingdom, subject to United Kingdom discipline, United Kingdom law, unquestionably within the jurisdiction of the United Kingdom.
Well,
That's
sorry.
it.
Please.
I was going to say, I'm just thinking of Article 5 for the moment. I mean, certainly,
Absolutely.
as far as Article 5 is
Yes.
concerned, they have the full protection of that, so far as the RMP, the military police, are concerned.
Yes.
But what about the Iraqi police? They may get hold of them in the souk and lock them up. It doesn't matter to them. They may
No.
not know that there's some arrangement that they don't have jurisdiction over them, but they may nevertheless detain them. What control does the UK have over that?
The UK might well have obligations to ensure the safety of their men. Now, what it might be is giving them appropriate guidance about where they should and shouldn't go and how they should conduct themselves when they go about their business. And of course, there will be limits in practical terms to what the British state can do. But that doesn't stop it having a legal obligation.
The UK hasn't locked them up.
No, the UK hasn't
And
locked
that's the
them up.
fundamental
Absolutely. It would be no
beginning
different.
point.
It would be no different from somebody who is kidnapped off a street in England and held to ransom
And then
legally.
the question is, to what extent is the
Is the
public
state-
authority in the UK,
Exactly.
are those
Obliged
acts
to-
attributable to them?
Obliged to protect them, yeah.
You
It's no
used the
different.
expression before, has a duty to protect, which I think is misleading in this context, just as guarantee is. What the consul or the diplomat has duty to do is not to infringe convention rights.
That's right, which in certain circumstances may include a positive obligation,
Yes.
including in relation to the duty to
Yes.
protect.
I was asking what duty is there to the consul by the UK? I mean, are we responsible for protecting our diplomats under the
Yes.
under the convention?
Yes, my lord. One would certainly expect diplomatic staff in embassies carrying out British governmental powers to be protected by the United Kingdom. But that, of course, is also a problem which we say doesn't arise in this case, because this case is analogous to the person who is subject to the authority of the consul, because Private Smith is subject to the authority of the British state.
I think of the right to vote. Was it Article
Yes.
3 of the first protocol that was invoked by prisoners?
Well, my lord, there's an interesting case, in fact, on the right to vote relating to British armed forces abroad. Because, in fact, what happened was a British expatriate complained that she didn't have the right to vote, whereas members of the British armed forces serving abroad did have the right to vote. Is that a loose authority, or is it in the bundle? Have it, is it down there? But in any event, what was said in that case was that British troops served, there was no discrimination, because British troops serving abroad are in a materially different situation from other British nationals abroad. Why? Because of their very close connection with the British state. Where is it? I'm grateful. It's tab 7 in file 18, the white file.
27, did you say?
Tab 7 in volume 18. So, at paragraph 1 on page 138.
There's another X v UK.
Yes, another, I know it's terrible, they're all called ex-UK. The Commission first considered the applicant's complaint she's wrongly excluded from the British electorate on the ground that she's no longer resident in the UK. And there's then reference to Article 3 of the first protocol and discussion of the principle. And then at paragraph 2 on page 139, insofar as the applicant may be understood to complain that the distinction made between her and members of the UK diplomatic service or armed forces stationed outside the United Kingdom who continue to enjoy the right to vote is discriminatory in the sense of Article 14, Commission considers the distinction pursues a legitimate aim and is not a disproportionate means of achieving it. In its opinion, these persons are not living abroad voluntarily, but have been sent to a country other than their own by their government in the performance of services to be rendered to their country. They therefore remain closely linked to their country and under control of their government, and this special situation explains that they are regarded as being resident citizens, although physically outside their country.
It doesn't say that they would have been able to complain if they hadn't got it, does it? However,
You might rhetorically ask the question, if the army members had not had the right to vote when they were abroad, could they have brought a complaint under the convention?
The rhetorical question I was asking myself.
Well, my lord, the answer in my submission is plainly yes. And given that reasoning by the Commissioner, it's inconceivable in my submission that the Commission would have held that they were not within the jurisdiction of the United Kingdom. This, of course, reminds one of a point that was made by Lord Mance yesterday. Lord Mance made the point that the original wording of Article 1 was that it referred to those who were residing in the United Kingdom, and that was then broadened to include those within the jurisdiction of the state. And he made the point that since armed forces are resident in the United Kingdom, it would be very strange if the effect of the broadening of the jurisdiction provision had been to take them outside its scope. And we respectfully agree. And the court can see here that they make the comment that they are regarded as being resident citizens, though physically outside the country. Yes, and Ms. Simon reminds me that there are cases, we referred to footnote 18 of our printed case, that a person who goes to a different part of the United Kingdom or a different country in the course of active military service doesn't thereby change his domicile, because he's not regarded as having voluntarily changed his place of permanent residence. That's perhaps a subsidiary point. But we submit that this is a powerful indication, this case, that armed forces remain within the jurisdiction in the sense in which it's used in Article 1. That brings me then to my next major topic, which is the question of the extraterritorial exercise of jurisdiction by a state in relation to its armed forces abroad as a matter of international law and as a matter of domestic law. And we have summarised our arguments on these points in our printed case at paragraphs 67 to 75.
Is this covered by Lord Bingham? I mean, he produced a very neat summary of all of this material, didn't he, in his speech? I think it was in Alscaney, wasn't it?
Yes, some of it
Yes.
was. Yes. I'm told it's paragraph 26. Just to summarise our position, I'm going to come back to each of these propositions. We submit that as a matter of international law, in general, a state which sends its armed forces overseas retains jurisdiction over them. The first proposition. The second is that in the absence of specific agreement with the receiving state, the actions of members of the armed forces may be immune from the receiving state's jurisdiction insofar as they amount to a sovereign act of the sending state, and that in other circumstances there may be concurrent jurisdiction between the sending and receiving state. Now, if we go first to Oppenheim, this is in volume 16, tab 157. This is the section on jurisdiction.
lower level.
Paragraph 1 through 6 just inside tab 157. Here is a general definition of jurisdiction. Tab 157,
Yeah.
paragraph 136, page 456. State jurisdiction in general. State jurisdiction concerns essentially the extent of each state's right to regulate conduct or the consequences of events. In practice, jurisdiction is not a single concept. A state's jurisdiction may take various forms. Thus, a state may regulate conduct by legislation, or it may, through its courts, regulate those differences which come before them, whether arising out of the civil or criminal law, or it may regulate conduct by taking executive or administrative action which impinges more directly on the course of events, as by enforcing its laws or the decisions of its courts. The extent of a state's jurisdiction may differ in each of these contexts. And just pausing there for a moment, if one considers the position of soldiers, they are subject to United Kingdom legislation. They are subject to the jurisdiction of United Kingdom courts, including the court-martial. And they are also subject to executive and administrative action and orders regulating their conduct. So we submit they are subject to all three of those broad forms of jurisdiction identified at paragraph 136.
Is it worth reading footnote 1, second paragraph?
The meaning of jurisdiction has had to be considered in several cases before the European Commission and Court of Human Rights, yes. So certainly no suggestion from Oppenheim that the Convention has a unique or special or different definition of jurisdiction from that which obtains in international law generally, quite the contrary.
No, but it was the second sentence of that little paragraph that was interesting.
That provision has been held to apply in various circumstances where a state has exercised authority or control abroad in a manner relevant to the exercise of the right in question.
It's that qualification, isn't it? I mean, I'm just thinking aloud, really, but that fits in with the idea of the consular official who's got limited functions.
Yes.
But so far as the functions that he does perform,
yes.
You're saying the Convention applies.
That's right. And of course, the situation of an army abroad is a pretty exceptional situation. And it's unusual, very unusual, for a state to exercise over individuals who are abroad the very extensive jurisdiction that a state exercises over its armed forces. That is unusual.
Well, except in relation to belligerent occupation, it's invariably governed by treaty.
Yes, yes. But, my lords, the fact that it's an unusual situation doesn't prevent it from being jurisdiction. It's indeed a much more powerful exercise of jurisdiction than that which one would normally see by a state exercised extraterritorially. So then, going back to the main text, jurisdiction concerns both international law and the internal law of each state. The former determines the permissible limits of a state's jurisdiction in the various forms it may take, while the latter prescribes the extent to which and manner in which the state in fact asserts its jurisdiction. Much of the law relating to jurisdiction is developed through the decisions of national courts applying the laws of their own states. Then the next paragraph, international problems of jurisdiction arise almost exclusively where a state, either directly or through proceedings in its courts, seeks to assert its authority over persons, property or circumstances which at least arguably are or occur abroad. In such cases, the questions which usually arise concern the actual or constructive location of the person's property or circumstances in question. If their location is abroad, the extent to which the laws of the forum state are to be construed so as to apply extraterritorially, and if they are so construed, whether the exercise of jurisdiction involves any infringement of the rights of other states or of generally accepted limits to national jurisdiction. And if your lordships leaf through this, I'm not going to read any more of it out, but for example, at paragraph 138, there is a section dealing with this jurisdiction over citizens abroad.
Before you get there,
yes,
the bottom of 460 and the top of 461 introduces the notion of immunity of armed forces abroad.
Yes, my lord, I'm very grateful.
Where is this?
It's the bottom of 460. International law gives every state a right to claim exemption from local jurisdiction, chiefly for itself, its head of state, its diplomatic envoys, its warships and its armed forces abroad.
But that's exemption for what one's armed forces do to others, not what's done to them. Is it?
Well, my lord, we're going to look at some
Article
case law on
15.
this. And there's an important case called Littrell, which we're going to look at tomorrow, which concerned negligent medical treatment of an American serviceman who was stationed on a US Air Force base in the United Kingdom. And he sought to bring an action in the UK court for negligence arising out of the way he'd been treated in an American hospital. And the finding was that the British court had no jurisdiction over that complaint because he fell within the exclusive jurisdiction of the United States government in relation to his welfare, because that was counted as a sovereign act. Now, we're going to come on to that tomorrow, but in my submission, the indication there is the exemption from local jurisdiction is not only in relation to what soldiers may do to locals, but also what is done to soldiers by their own government while they are abroad.
Yes, that's one.
My lords, I don't know if that's a convenient moment.
I think it is. Thank you very much, and we'll adjourn until 10 o'clock tomorrow.